Good afternoon, this is Sean Golding with Golding & Golding here to discuss a little bit about the green card, FBAR noncompliance, and the risk to green card holders about whether or not they can be deported for not being in compliance. This is important because the 2024 FBAR is coming due by October 15, 2025, and it's on everybody's mind. We get a lot of questions about this. So let's start from the beginning. The FBAR is foreign bank and financial account reporting. It's not a tax form. It's not used to report your taxes if you're a U.S. person, individual, or entity. You have certain foreign accounts, assets, and investments. You're required to file the FBAR. This includes things such as foreign bank accounts, investment accounts, stock and fund accounts, pension, life insurance with a surrender value, etc. As I mentioned, it's not just for individuals, but the focus for this, of course, is individuals. If you're a U.S. entity and you have foreign accounts as well, you may be required to file the FBAR. There's other forms such as the 8938, 3520, 5471, but the focus here is the FBAR. So green card holders are at risk in general compared to, for example, a U.S. citizen who is naturalized. They don't have the same set of rights. Recently, under the current administration, there's been an increased amount of enforcement against green card holders, even citizens, but green card holders and H-1B visas and L-1 and things of that nature. So if you have a green card and you have foreign accounts, well, in general, if you have a green card, you should focus on being in compliance, just because why muddy the waters if you don't have to, right? And also the Supreme Court years back had affirmed that tax fraud is something that is a deportable crime. Now, is not filing your FBAR tax fraud typically not, but we're going to go through a couple of examples, and in the third example, sometimes it can be entwined between failing to report income, failing to report the accounts. When you look at it as a whole, it could lead to a deportable crime. So let's start with the first example. Jennifer is a lawful permanent resident. She's been living in the United States for a few years. She has her green card. She files taxes. She has a green card, so she's from a foreign country, wasn't aware of the FBAR. All the accounts are in the country where she's originally from or where she worked. There's a good likelihood, as long as she proactively gets herself into compliance, she's probably not going to get deported or removed for not filing the FBAR. Second situation is also very common. Let's say David is a lawful permanent resident as well. He's been filing his tax returns. He's been filing the FBAR as well. But he was mistaken about whether he has to report foreign pension accounts. On the FBAR, he previously worked in a foreign country, so the pension accounts are a pretty significant value. Just because they're a significant value, though, he didn't intentionally fail to exclude them on the FBAR. He wasn't aware. He did file the FBAR for the accounts he knew about. Chances are, if he fixes it, gets into compliance, probably not deportable. The third example is where we start to get into some trouble. So here, Scott is a lawful permanent resident as well. He's very wealthy. He has a lot of foreign-sourced income. That income is being sourced from foreign accounts and investments. Scott doesn't want to report this income, so he artificially reduces his income on his U.S. tax return by not including the foreign accounts. In addition, by not including the foreign income, but in addition, he doesn't include the foreign accounts because he's concerned that there would be some string that runs through the foreign accounts and the foreign income, and it'll lead the U.S. government to realize that there must be income. So if he reports all the accounts, but he doesn't report the income, then the IRS can be like, well, you've got all these accounts. Is your position that it's not generating any income? So let's say he doesn't report the FBAR, doesn't file the 8938, doesn't file the FBAR, and then he's audited. And during the audit, the IRS agent isn't buying it. So he gets referred to the IRS special agents. The IRS special agents conduct an investigation. They think it's criminal. He's indicted and ultimately convicted of tax fraud. Because of the Supreme Court case that says tax fraud is a deportable crime, the fact that he didn't file the income, didn't file the FBAR, could potentially lead to him being deported for not reporting income and reporting the FBAR. Now, if someone is out of compliance, there are various ways to get into compliance. When you're non-willful, you have things like the streamlined procedures, delinquency procedures, and reasonable cause. If you're willful, you can do the voluntary disclosure program and get yourself into compliance. And this may help avoid any potential deportation or removal. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.